Hello everyone, I'm Dr. Sapna Didwal. I'm working as a professor in the Department of Management at St. Andrews Institute of Technology and Management. This is lecture 11 of Consumer Protection. This is the subject which is taught in BBA 6 semester. As from the last two lectures we are discussing MRTP Act. We have already discussed the objectives, all three objectives of MRTP Act. MRTP Commission, objectives, and we have discussed individually also in detail all three objectives of the MRTP Act, that is monopolies and restrictive trade practices. Then monopolistic practices, then monopolistic trade practices. Second objective was restrictive trade practices. Third objectives were unfair trade practices. We have already discussed all these objectives in detail and the regulations of these objectives also. Now the next topic, the topics in this lecture I am going to cover are role of MRTP Act in consumer protection and the remedies available to the people under the MRTP Act. Then procedure for filing a complaint under MRTP Act. Then I am going to start the second topic of Unit 3, that is Competition Act 2003. I will be giving you introduction. We will be discussing objectives of this Act, Competition Act, and will you give brief idea about the basic provision of Competition Act 2002. So I am starting with first topic of this lecture, that is role of MRTP Act in consumer protection. The MRTP Act provides protection to consumer interest in the following ways. The first is protection against monopolistic trade practices. The monopolistic trade practices lead to traders against the public interest. It is a common knowledge that monopolistic positions lead to certain practices which are against the interest of the consumer. Thus, monopolistic practices are against the interest of the consumers. And in such a situation, an undertaking has the power to dictate the prices of the commodities or services it supplies, and it regulates its volume of production in such a way so that it can maximize its profit. So, with restriction or monopolistic trade practices actually result into the increase in profits, increase in prices, and increase in the profit of the organizations only. So in order to protect the interest of the consumer, MRTP Commission conducts an inquiry into monopolistic trade practices and submit the report to central government. The central government may pass an appropriate order for regulation of production and fixing the terms of sale or fixing standards for goods produced. Now the second is protection against restrictive trade practices. MRTP Act provides protection to consumers against restrictive trade practices also. Restrictive trade practices reduce or prevent the competition in the market to maximize their profit. So these practices have adverse effect on the consumers' interest because it may result in manipulation of the prices. So MRT Commission has the power to conduct an inquiry of any such restrictive trade practice and can order for discontinuation of the practice and prohibition of resale prices. The third one is protection against unfair trade practices. Any trade practice which is harmful to the consumer is an unfair trade practice. Before the amendment of 1984, the MRTP Act did not have such provision for the protection of consumer from unfair trade practices. So, unfair trade practices means misleading advertisement, hoarding of goods, supply of unsafe products, etc. So, if MRTP Commission may inquire into any unfair trade practices, and if they find the complaint to be true, then they may pass an order for discontinuation of such practice, or non-repetition of unfair trade practice, or declaration of any agreement as void related to unfair trade practices. Now the next topic is remedies available for the consumers under MRTP Act. The first main remedy is against unfair trade practices. The following remedies are available to a complainant against unfair trade practices. The first one is temporary injunction under section 12A. The MRTP Commission, after an inquiry into the complaint, and if it proves, or if the Commission finds that there exists unfair practice, then it may grant temporary injunction restraining such person or undertaking from continuing to carry on the unfair trade practice until the conclusion of such inquiry or until further orders. Now, second is award of compensation under section 12P. So, whereas result of unfair trade practice, any loss or damage is caused to a trader or a consumer, the Commission may, on an application made to it in this behalf, determine and pass necessary order for payment of compensation for the loss or damage of so caused. Now, third one is cease and desist order. After completion of the inquiry against unfair trade practice, if the Commission is of the opinion that the said trade practice is prejudicial to public interest or to the interest of any consumer, it may pass a cease and desist order directing that such practice shall be discontinued or shall not be repeated again. Now the fourth one is declare as void or modified an agreement relating to unfair trade practice, that is section 36D. The Commission may declare agreement of unfair trade practice as void or an order to modify the same. If then order of issue of contract correct advertisement. The Commission may by order direct the person or undertaking indulging in any unfair trade practice in addition to the cease and desist order or order modifying any agreement or declaring any agreement void to issue any corrective information statement or advertisement, and may also specify the manner in which such information statement or advertisement may disclosed, issued or be published. The sixth one is accept undertaking from the party. The Commission, instead of making order, may at any time during the inquiry accept an understanding from the party to any unfair trade practice to take adequate steps within the prescribed to ensure the trade practice is no longer against the public interest. Now the second main category is remedies against trade practices, restrictive trade practices. Remedies against restrictive trade practices. Under this, first will be temporary injunction as same. So during the course of an inquiry against restrictive trade practices, the Commission may grant temporary injunction restraining any person or undertaking from indulging in any restricted trade practice if it is proved that carrying on of such practice is likely to affect the prejudiciary interest of the public or any order or any trade or consumer or any class of consumers. So it may temporarily inject the trade practices. Then second, compensation. Yes, if it is proved that as a result of restrictive trade practices by person undertaking has caused loss to the consumer or trader, the Commission, on an application made to it seeking compensation, may determine the amount of compensation payable to the aggrieved party. Then cease and desist order. After completion of inquiry under Section 37, if the Commission is of the opinion that restrictive trade practice is prejudicial to the public interest, it may pass cease and desist order to the effect that such practice shall be discontinued and shall not be repeated. Then declare void. The Commission may declare such agreements void or modify in a prescribed manner. Then fifth is accept an undertaking. Yes. Then at any time during the proceedings or after completion of the inquiry, the party to any restrictive trade practices may accept or may give undertaking to take corrective steps towards this restrictive trade practices, and Commission may accept this undertaking from that party that they will take step to ensure that there will be no repetition against the public interest of such practices in the near future. Now the next topic is procedure of filing complaint. The complaint should be made in accordance with the performa given under Section 10A of the MRTP Act. It should contain all the facts that constitute the base for complaint. The original complaint should be accompanied by 4 copies for the Commission's record. Complaint statement of the case and other pleadings are to be signed and verified before the Commission. On receipt of the complaint or references and on consideration of any evidence on record, if any, the Commission will issue a notice of inquiry. Notice of inquiry must be accompanied by a copy of the complaint or reference as the case may be. Notice should bear the Commission seal and must be served to the related parties. A respondent on whom notice of inquiry is served is asked to appeal before the Commission. At least 10 days time should be given to the respondent. Now the next topic is Competition Act 2002. So in view of the criticism of MRTP Act, the government introduced a competition bill in the Parliament known as Competition Bill, a bill in 2001, and this bill was passed in 2002. The act is called as Competition Act 2002. The act was amended in September 2000 again with the coming into effect of the Competition Act 2002. This act actually came into force in 2002. So, with the act coming into effect, the MRTP Act 1969 was repealed and MRTP Commission was dissolved. So, this act applies to whole of India. It is a landmark legislation that aims at promoting competition through prohibition of anti-competitive practices, abuse of dominance, and regulation of combinations beyond a certain size. The Act provides for the establishment of Competition Commission to control these practices. The Act was passed with the following objectives. The first is to provide for establishment of a commission to prevent practices having adverse effect on competition, Second is to protect the interest of the consumers. Third, to promote and sustain competition in market in India. Next one is to ensure freedom of trade carried on by the participants in markets of India. Then to regulate the combinations. Then to promote competition through prohibition of anti-competitive practices. Then to prohibit abuse of dominant position. Thus, from the above objective, it is very clear that the Competition Act 2000 is designed for the following purposes. First was prohibition of anti-competitive agreements, then prohibition of abuse of dominant position, then regulation of combination. I would like to give you a brief idea of prohibition of anti-competitive agreement. So section 3 of the Act makes provision for prohibition of anti-competitive agreements. According to this, no enterprise or association of the enterprise or person or association of persons shall enter into any agreement in respect of production, supply, distribution, storage, acquisition or control of goods or provision of services which causes an adverse effect on the competition within the India. The second is prohibition of abuse of dominant position. So, according to section 4 of the Acts, it says that no enterprise shall abuse its dominant position. It may be noted that dominant position itself is not prohibited, but misuse of dominant position is prohibited. It is very clear that use of dominant position is not prohibited. Misuse of dominant position is prohibited. Now, dominant position means a position of strength enjoyed by an enterprise in the relevant market in India, which enables it to operate independently of competitive forces prevailing in the relevant market, or affects its competitors or consumers or the relevant market in its favor. Now, the third one is regulation of combinations. So, section 5 of the Act defines that the acquisition of one or more enterprise by one or more person or merger or amalgamation of enterprise shall be treated as combinations. So, amalgamation or merger of one or more persons shall be treated as combination of such enterprises, and the person or enterprises in the following cases: acquisition by large enterprises, acquisition by groups, acquisition by enterprises having similar goods services, acquiring enterprises having similar goods services by a group, merger of enterprise, merger in group company. So, section 6 of the Act says that regulation of combinations, that no person or enterprise shall enter into a combination which causes or likely to cause an adverse effect on the competition within the relevant market in India, and such a combination shall be avoided. Now, basic provisions of Competition Act 2000. First is a competitive commission. The Competition Act provides that there shall be established by the central government a commission to be called as Competition Commission of India, consisting of a chairman or chairperson and not less than 2 or not more than 10 members. The chairperson and other members shall be whole-time members, and every one of them shall be a person of ability, integrity and standing, has been or is qualified to be a judge of High Court, or has special knowledge and professional experience of not less than 15 years in international trade, economics, business, commerce, law, finance, accountancy, management, industry, public affairs, or in any matters which in the opinion of central government may be useful to commission. The second basic provision is anti-competitive agreements. The Competition Act declares void agreement in respect of production, supply, distribution, storage, acquisition, or control of goods or provision of services which causes an adverse effect on the competition within the India. Then third is abuse of dominant position. Section 4 of the Competition Act lays down that no enterprise shall abuse its dominant position. Dominant position means a position of strength enjoyed by the enterprises. So there are three basic provisions in Competition Act 2002. So these are the questions which are related to above topics we have discussed in this lecture. If any query is there, please do contact me. If any writing mistake is there, please do ignore that writing mistake. Thank you so much.